We'll continue with our patent session as Evelyn was making a mention. So this is one of the earlier slides which we had a look at. This is a graphical representation of one of the most important part of patent discussion, that is patent registration procedure. In fact, we went into this and we had at least a reasonable kind of discussion with this. So there are two parts for patent registration. We would say the procedure of patent registration can be divided into two parts. That's what I meant. So that is one part, or first part is up to grant and grant a patent, and the second part is procedures after patent is granted. These are the two parts of the procedure, we can say. So this is what we discussed, and we almost stopped at that place, and we were supposed to move further. So we'll be spending some more time on examination of patent application and the and registration related things. So examination of patent application. So we had a look at the patent procedure as such, graphical representation we had a look at. And when a patent application is received at the patent office, along with the specification, what are the things that would happen there? It's important for us to have an understanding about it. So examination of patent application. Examination of patent application, usually it will not be examined unless if you are the patent no, applicant, like if you are the applicant, unless you make an application for making an examination. And examination would mean, and the purpose of which will be that the patent application is examined to see whether it complies with the requirement of a patentable invention under Patent Act 1970. That's the very purpose of patent examination. So there is a particular format for that, and we are not concerned about all this. So the person who is looking after this affair of examining the patent application is known as examiner, patent examiner. There are different departments in patent office. So chemistry and allied subjects, that could be one of the illustrations. Biotechnology, microbiology, and allied subjects could be another department of cell which takes care of that area concerned. And electrical, electronic, and related subjects will constitute another department, and mechanical and other subjects. This is just to give you a feel about how scientific, within double inverted commas, how scientific is patent procedure is and patent office could be. And usually, unless otherwise provided, unless there is a continuation of period and delay, usually a patentability report, a report on patentability will be released, will be handed over to the patent claimant within 3 months of the examination. So the idea is this: what we are talking about is the patent procedure. In that, we have a patent application being examined by the patent office, and the person who is taking care of that is known as examiner, and he'll be looking at this patent application to verify whether it has got all the patentability, it is complying with all the patentability requirements or not. And this report, which is known as report on patentability, will be handed over to the patent claimant, the applicant, within 3 months of the examination. That's a period. And moving further with this idea, a search for anticipation by previous publication and prior claiming. I hope from our previous discussions, we have an idea about what it is. See, search is made, or the examination is made by the patent examiner to verify if the patent or the invention as claimed in the patent application is anticipated, whether it is already known, we can say, whether it is already anticipated, it is anticipated by prior publication anywhere in the world. We already said that. So prior publication or previous publication anywhere in the world could mean patent documents, or it could be any other kind of document. We had some of the no, some of the cases which were good enough to throw light on that particular idea. Or it could be anticipated. Patentability could be patentability, requirement can a patent, an invention can be considered to fail the patentability requirement if there is prior claim. If a prior patent application contained the same idea as that which is considered, which is being claimed here. So if it is prior claimed or if it is prior published, then there is no patent. So to examine this, whether it is previously published, whether it is previously claimed, that will be examined by the patent examiner in the patent search, patentability search document. And moving further with this, now you have Indian patent database starting from 111 1912. The importance of that date is this. This is the date on which the patent office was constituted or established. And they also look at, the patent examiner will also look at EPO, European Patent Office Database, WIPO, World Intellectual Property Organization Database, USPTO, United States Patent Trademark Office Database, and JPO, Japanese Patent Office Database, TKDL, and that is uh, traditional knowledge digital library, which India holds, and other paid databases, including Google patent search. Google patent database is there. Google has a patent database as well. That may be some an information which will interest you perhaps. So these are the websites and the databases that be considered by the Indian patent examiner. And Indian patent examiner will look for the compliance of PCT. PCT is none other than nothing but it is a international treaty, patent cooperation treaty of 1970, which facilitates or makes the procedure for filing patent applications in different jurisdictions easy. So rather, this is not a substantive treaty. All of us know what substantive is. So it does not speak about the substantive requirement of a patent application that is provided in the TRIPS agreement, and those have been incorporated in the concerned laws of India or any other country. So Indian Patent Act 1970 is in compliance with the TRIPS agreement in substantive matters. And this treaty, Patent Cooperation Treaty 1970, of which India is also a member, this treaty facilitates easy filing and multiple the filing in multiple jurisdictions easy. So, but please do understand there is no international filing as such. You will not be granted an international patent from any patent office, and even WIPO does not have such a system. Please do understand. But this treaty, Patent Cooperation Treaty, will provide a mechanism where you will be able to make patent applications simultaneously in different jurisdictions, and it has got certain other advantages too. So, Patent Office of India, when it receives a patent application, as we said, it will look at Indian Patent Database and Indian Patent Office documents. Apart from that, EPO, WIPO, US database, Japanese database, and even Chinese and some 6 jurisdictions mainly. They'll be looking at all these, and they'll be looking for the fact. They'll be verifying the fact whether it is complying with the requirements of a patentable invention or not. Yeah, moving to the next slide. So the requirements of patentability we have already looked at, and the requirements are novelty. We know that it should be new. It should have inventive step, or it should be non-obvious, and there should be industrial applicability or utility. And there is another requirement: the invention not patentable if invention will not be patentable if there is no sufficient disclosure. As we said earlier, if there is no disclosure of the best known method, the best known method available with the claimant or the patent applicant, if there is no sufficient disclosure, as sufficient disclosure will be nothing but a disclosure. The level of disclosure should be such that a person who is expert in that particular area should be enabled to operationalize the invention and come out with the outcome of the invention or the product or process, whatever it is. So there is a sufficiency test there. So 3+1: novelty, inventive step, and industrial applicability, and sufficiency of disclosure. These are the four substantive matters that will be looked at by the patent examiner, and a report will speak about these four requirements. They will say whether the requirement, the patent application complies with all the four or not. If it complies with, it's good. If it is not complying with it, then it's bad, obviously, for the patent claimant. Okay, moving further with this, and a report of the examiner, which first examination report. It is known as FTR, a report of examination, like report of the examiner, and so it will look at whether it is complying with the requirements of Patent Act, whether there is any lawful ground of objection to the grant of patent under the Act, and the result of investigations under Section 13. So it's complying, whether it is complying with all the requirements, and whether it is already known to the world by way of traditional knowledge or not. All these will be examined, and it will be communicated to the applicant. So once the report is out, once examination report is out, it will be communicated to the applicant, and the applicant will have a period of as much as 12 months, which can be extended in some cases, but usually it is 12 months period, which people like you and me, if we are examiners, will get to examine, will get to respond to this objection if it's there. Then what happens is we have an opportunity to amend the patent application. Amend in the sense you can remove certain portions of your patent application if only that portion is already known to the world. It can be amended, or certain things can be added to that, or certain things can be substituted, but substantial part of it, substantial nature of the patent application, substantial nature of the invention cannot be changed. You can only make such amendments which are necessary for the purpose of overcoming the objection without affecting the basic, the basic invention. So you can give explanation for that, and you can produce documents. It will be something like a court proceeding, a quasi-judicial proceeding, and it's possible for you to go for a refiling. All these are possible once you get an objection from the patent office in the form of examination report. All these are possible, but one condition, and it is an important condition, that is, it should not it should not it should not change the basic substance of the patent, the invention. And there can be a hearing also in front of the controller of patent. All these can be done, and if you could come out colorful, if you can succeed, if you can successfully explain out the objection, then it goes further. So once you are through with your application with the patent examination has happened, and there was no objection. Either it could be one of the possibilities, or if there is an objection, and after hearing and production of documents, all those, if you come out successfully, then there is another procedure, another challenge you have to face. That is called as a pre-grant opposition. So to see this holistic, once you make an application, there is a twin wing procedure to see that it is complying with the patent application, is complying with the patentability requirements. One, as we have already seen, it is an examination by the patent office. But howsoever comprehensive a person makes an attempt to include as many things as possible in his examination, it is not possible for anyone in the world. It is impossible for anybody to examine each and every knowledge stock available with the humankind. Patent documents, which is being considered for the purpose of a report of examiner, is just one part of it. Just one part of it. Of course, it's an important part, but it's just one part of it. But there are very many, knowledge which is not in the patent documents. It is known to the world even otherwise. So, taking into consideration this practical reality and this common sense, Patent Act says even after patentability examination done by the patent office, even if you come out colorfully after this, there is another challenge you have to face. The challenge is pre-grant opposition. Before being granted, there is another challenge, that is there is an opportunity given to no, given to general public, which can include any Tom, Dick, and Harry. Any person interested in can make an application, can make an objection. So one procedure is that of an examiner, another one is from the public, pre-grant opposition. So what patent law says is any person can make an objection, any person can make an opposition, and at any time after the publication of the patent application, at any time would not mean that at any point of time it is it is unlimited time period. No, there is a time limit for that, and the representation, statement, and evidence request for hearing is so desired. So, a similar proceeding, which is similar to the court proceeding, can happen here also, because there is a person who is opposing your point of view. You have made an application claiming that you can be granted with a patent, uh, but there is another person who comes out with another company which says that we have got an invention, we have got a machine, we have got something which is already known, and what you are claiming patent for is something similar to that of what is already, which is already known to us. That's a situation. That's a situation of pre-grant opposition by the public. There also a similar situation that as there quasi-judicial proceeding can happen, and then if pre-grant opposition, if available on record, no, no, then it will be considered by the controller. So when the pre-grant opposition done by any other person in any other patent application, please note this may be a little complicated. It could be. See, it's not only earlier patent documents, documents with regard to which a patent has already been granted, that will be considered by the controller, but also an unsuccessful patent opposition will also be considered, can also be considered in the hearing. Meaning to say that as far as the earlier opposition, the situation is like this: there was an earlier patent application, and there was an opposition in that, and in that opposition, certain documents were produced. But nevertheless, that patent opposition was not successful. That was a failure. So, as far as that patent opposition is concerned, that was a failure. But even that document can be considered by the controller while hearing this, the present patent, what do you call the patent claim, or the patent claim and opposition. And if the present patent is similar to that of which is already, which is similar to that of the document which is already produced in the earlier document, then also the present patent application can fail and the present opposition can win. That possibility is there. It's commonsensical. So even though it is not useful as far as the earlier patent application is concerned, it could be, useful as far as the present patent application, uh, as far as present application is concerned. So moving further with this, grant a patent and then consequences. Once the person comes out colorfully, overcoming the examiner and overcoming the public opposition, he will be granted a patent. No, and what's the consequence of a grant of a patent? On the grant of a patent, there will be a serial number electronically produced, which will be granted to the person. It will be as good as, or yeah, it will be as good as an admission number which you get once you take an admission in an educational institution. It will be unique. That will be a unique serial number granted to every patent, which will be different from any other number. It's a unique number granted to a patent, and there will be a certificate. We already had a look at a patent certificate earlier, so we will not spend much time on this. A certificate of patent will be granted, and the entries will be made in the e-register. There is electronic register now. Everything is online, and even registers are electronically available. And sufficient entry and sufficient information regarding the patent grant, patentee, and all those will be made in the e-register. And complete specification is made available to the public through official website. If you go to Indian Intellectual Property Office of India, you have different pages, different sections wherein you get information regarding patent as well. So through that website and their journal, the information of grant of patent will be made known to the public, and once it is as good as saying that it will be published in the official gazette. And the fact of grant is published in the official journal. That's what I said. And moving further with this, once granted, what are the rights available to the patent? That's what we are going to have a look at. So if you are granted with a product patent, we know what a product patent is. So the kinds of rights which are protected as patent are: one, the exclusive right of making the product, exclusive right of using the product, exclusive right of offering for sale, exclusive right of selling, exclusive right of importing and exporting. So what you get to see is you have got only you can do business with regard to that. All the business interests, in the jurisprudential sense, the interests which are protected, which are recognized and protected as patent, are all business interests. Just have a look at that. A product patent holder will have the exclusive right of making, using, offering for sale, selling, importing, exporting, everything. So, and as well as process patent is concerned, he also has got similar rights. What we can keep in mind is he also gets the person also uh, uh, gets a bundle of rights which are business rights: using the process, offering for sale, which are the outcome of that process, selling of the products which are an outcome of the process, and importing. So a number of rights or number of interests, or the width and uh, width and volume of interest may be different. For obvious reason that this is only a process pattern. So these are the two sets of bundles of rights available to a patent, depending on the nature of patent that is granted to patent holder, and the product obtained directly by that process. It says. So rights of patentee, we already had a look at that, and now date of patent. Now date of patent is also something to be understood. Date of patent, as we have already mentioned, does not start from the date of grant. Please note, it does not start from the date of grant, but it starts the date of from the date of application. It dates back. Usually, it takes 3 to 4 years for the procedure to get over and a patent to be granted once a patent application is made. So, if you make an application in 2020, no, no. Generally speaking, it takes 3 to 4 years. So, you will be granted a patent in 2023 or 24. Even though it is granted in 2024, then your patent it will be valid from the date of patent. From the date of patent, in the sense from the date of application. So, in other words, you can say that you have a right as a patentee from the very date of your application, from the very date of priority. So, from the date of priority, you are a patent holder. You have got all the rights. You have got all the exclusive rights available to the patent from the very date of application, from the very date of application, that is date of patent. And term of patent is, as it is already known, it is 20 years. 20 years from the date of patent, that is the date of application. Moving further with this, we also said when we had a look at the what you call the chart or the diagram, there is a possibility of post-grant opposition as well. Once a patent is granted, it is not final there. Even after the grant of patent, it's possible for any person from the public to make an opposition to a patent which is already granted. That's possible. So we will just have an idea about that also. And post-grant opposition can be filed, can be made by any person interested. Any person interested would mean it is open to the general public to make an opposition to a patent which is already granted for which a certificate is available. Even against that, you and I can make opposition, which is known as post-grant opposition, within 12 months from the date of publication of grant. And please also note the fact that patent, even after this period of 12 months, even after the period of post-grant opposition, there is possibility of making application for revocation of patent. So what we can conclude is this: patent document or a patent certificate cannot be considered to be equal to a title deed. It can be opposed at any point of time. Within 12 months, a patent can be opposed. Even after grant, it can be opposed within 12 months. And even after this period of 12 months, this maturity period, there is a possibility of revoking a granted patent. So patent is always a risky document, and it will depend on how sure you are, if you are the patent holder, about your patent, and how good is your patent. It will depend on all these factors. So we would conclude our discussion for the day as per our understanding. Our sessions will be for half an hour here and after, and we have to discuss the matters relating to infringement of patent and related things, and that will be a good discussion for half an hour or so. So that could constitute another composed, composed and crisp, if I can say so, crisp discussion for half an hour.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും. See, 80 Article 80 is what about the composition of the Council of Composition of the